Hello everybody, here we go with Lecture 13, Jury Trials once again. Lecture 12, of course, as you probably remember now, is about jury selection and that process and the various strategies that attorneys use to select jury members or reject jury members, whichever the case may be, and how some personality constructs might figure into jury decision making as well. Now we're going to talk about the process of deliberation to a greater extent. So before we were talking about building a jury, now we're talking about what happens with the jury once they've been built. How do they process information? So, concerns and reforms, let's get started there. What do we know? We're going to talk about jury nullification as one topic right off the bat. And we're going to talk about the question, are juries competent? That is, can they fulfill their decision-making criteria? And think about this. This really goes back to Lecture 9 when we were talking Miller and Bolster and about the trial process itself. Is it a fact-finding mission, and to what extent can people successfully separate truth from fiction? Can they weigh the evidence in a way that's rational and useful? And this we'll talk about it in terms of opening statements, determining liability in civil cases, a little on that. We already know that jurors tend to be very much in line with judges' awards in civil trials, but remember the juries from the Vidmar, Hans and Vidmar research especially, that juries show more variability than judges, but that would be to be expected. That's pretty easily explained. We'll talk about assessing damages and what criteria people use. We'll talk about instructions to the jury and how does the jury comprehend those instructions. We're going to kind of wrap that all together in what's called the story model, which can be kind of a summary or overview. And then I'm going to show you some research about concern for the social order as well. So, and that's research that we conducted. So, jury nullification, should we keep it a secret? Well, when the jury acquits a defendant who's legally guilty because they disagree with the law or its application, then jury nullification has come to pass. And what this is saying, in spite of the evidence, we don't believe that, in fact, the defendant should be found guilty, although the evidence clearly indicates they are. The jury has this power, and they can do this. There's really nothing to stop this from happening. But it's not a right, so there's nowhere written in the law that the jurors have the power to nullify. It is just part of the process. Big question, though, in this regard, is should judges tell the jury that they have this power, right? And how would that work? So Horowitz did a study, and they used two variables. They manipulated the type of offense, so they used 3 different offenses, because we're finding out from this research that the nature of the offense does matter, right? And then the instructions to the jury was the second independent variable that was manipulated. So you have 3 different crimes, and then the manipulation from there is, does the judge give a nullification instruction, or does the judge not give a nullification instruction? So that's our laboratory paradigm here. We got a 2x3 design. And then what is the dependent variable? Is simply the verdict on a scale from 1 to 6. And 1 is very confident, not guilty. Right? So not guilty down here. And then 6 is very confident, guilty. So let's keep that in our heads when we look at the chart. So, the Horowitz results then. First of all, the first case that was described was drunk driving, then there was euthanasia and illegal possession of drugs, cannabis. So, what we see then in the drunk driving case, the nullification instruction is the bar on the right, and we see that the verdict scores leaned more towards guilty when people were given the nullification instruction than when they were not. And this is what we often call a counterintuitive finding. We would expect globally that nullification instructions should increase the prevalence of nullification, and then we should see the average guilt go down. In this case, it was just the opposite. So what we're now thinking, okay, is the hypothesis just totally refuted, or is it a more nuanced hypothesis? Notice in euthanasia, when it was a mercy killing by a family member and nullification instructions were given, then not guilty, in fact, increased over guilty. So you can see that this is really a situation-specific idea of giving nullification instructions. How do they affect the outcome? And we see a similar situation where illegal possession, someone was arrested by a narcotics officer for illegal possession of cannabis, and we see that the nullification instruction greatly reduced the conviction rate, or the perception of guilt, I guess is the more specific term there. So, does it help? Does it not? It depends. And remember, that's the favorite word. It depends. And then we come back. Depends on what? Well, it depends on the nature of the crime. So, jury nullification then has racial undertones in this country. That is, if you have an all-white jury in the South, and I'm going to go back to the South as we did in the last lecture because this is where it was most often observed. If we have an all-white jury and a white defendant in the South, and the white defendant committed a crime against a black person, even though the evidence might be overwhelming in favor of guilt, the jury wouldn't pull the trigger, so to speak, on the white defendant. And this would be an example of nullification. And this is one of the concerns because it has these tremendous racial undertones. Now, the flip side of this, right, because if there's if there's jury nullification, is there such a thing as jury vilification? And this, how would we define that? This is when the jury ignores the law or the evidence and convicts someone, even though they should legally be acquitted. Okay. Now, this hasn't become a hot topic. Obviously, it's just as heinous as the other way around, necessarily, if you want to frame it that way. But if someone's convicted and they're wrongly convicted and they can demonstrate that the jury was not fair in this conviction, then it opens the door to appeal. So appeal options operate in this direction. Notice in nullification there is no appeal because there was no conviction, so appeal never becomes necessary. And if there was no conviction, then retrying is not possible because of double jeopardy. So scholars agree that juries do not should not exercise the power of jury vilification. Right? And how might jury vilification occur? We go back to our example of O.J. If people believe that O.J. literally got away with murder, and then later he's in court for recovering what he alleged to be stolen property in a forceful manner, is it possible that the evidence really didn't reach the threshold of guilt under normal circumstances, but because there's a perception that O.J. got away with murder previously, we're not going to let him go this time? Jury vilification then might be the result of that process, among other possibilities. Consensus nullification should occur when community has objections to a law, but not as a kind of retaliation against the police and or the government, although it can occur for that respect, in that regard, to some degree. Okay. Let's move on to the competence of juries. Are juries competent? And obviously we're not going to look at every aspect of jury decision making and hold it up to the competency evaluation. But in this case, do juries do a good job? Well, let's start with opening statements. Opening statements are interesting because obviously this is what occurs at the beginning of the trial, and they're not considered evidence. It really is opinion, it's not evidence. So it's, kind of setting the stage for what's going to occur in the trial. So how do people process opening statements is a critical aspect of understanding how the entire process works. The power of opening statements, and this is by Pazinski and Reitman, 1981, and what they manipulated in this case was brief versus extensive opening statements. So, and then you give the opening statements and you stop at that point and you say, okay, so what is your assumption of guilt or innocence, right? Or the benefit of the doubt, as it was termed here. Brief statements, juries started with the benefit of the doubt. Extensive statements started by assuming guilt. So if a prosecutor wants to kind of shift the trial in their favor, the lengthening of that opening statement might in fact cause the jurors to assume guilt of the defendant when they should be assuming innocence at the beginning of the trial. Follow-up. So either defense or prosecution gave opening statement first. Let's stop right there. Who normally gives the opening statement? Yes, that would be the prosecution, right? But if we manipulate it within a laboratory setting, within a mock trial, if the defense or prosecution gave an opening statement first, when the defense went first, more likely to find not guilty. So these are some really kind of interesting findings that look at the process. What we're saying then, if the defense was allowed to give opening statements first rather than the prosecution, would that mean overall that our justice system then would generate more not guilty verdicts? And that's a fascinating thing to think about. Again, hard to take this from what we observe in the laboratory to what might manifest itself in the courtroom, but that's the evidence. What else about opening statements? Why are they so damn powerful, right? Well, opening statements set a thematic framework. And what does that mean? That guide people through the processing of new info and help them interpret ambiguous and missing info. Consider this, that, you know, how many of you actually sat on a jury? How many of you actually been jury members? And almost none of us have any experience in this whatsoever. So we walk into the courtroom, and maybe we've never been into a courtroom before. So everything is new and novel to us. We really don't know what we're doing, necessarily how we're supposed to behave, what's expected of us. We've entered into a relatively ambiguous situation. So we look for guidance to help us make sense. We also look for guidance to help us pick the schemas or scripts that we should use to make us more successful in moving through this endeavor called the trial process. So the opening statements then become particularly powerful because it can set the schema. It can begin to create a narrative which we grasp onto to make sense of a rather confusing situation. In this study, and this is really a kind of tricky one, in this Pazinski et al. 1981, the false opening statement promise study is what they called it. What does it mean? Defense promised in the opening statement that an alibi would be presented, and the manipulation of the variable to the control condition, or said nothing about it. Regardless, in both cases, so here we go, we randomly assign participants. Some have been promised an alibi in the opening statement, no alibi mentioned in the other opening statement. Then these two groups of participants go in, they hear the same case, they hear the same evidence, right? In both cases, no alibi is ever presented, so it was a false statement. Those who heard the false statement, those in the condition of the false alibi statement, were more likely to acquit. That is to find the defendant not guilty, even though the alibi didn't exist. And this is a powerful example of this kind of setting the framework, setting the schema. Oh, well, there's going to be an alibi. And the whole case proceeds. There never was an alibi. But when we get to the end of the road, well, then for at least some folks, they're thinking that an alibi was in fact presented, although it wasn't. So very, very under the radar. Okay. Now, let's look at this issue of juror bias and can it be corrected. We've talked about corrections. We talked about Wilson and Brecky and the correction process earlier in the course. This is some research we did, and I'll say that I doubt this research could be conducted now. The IRB has become more stringent. When we were researching this, we were able to just generate experiment after experiment after experiment, creating new materials all the time. The IRB just said, oh, you're studying crime, you're using stories, okay, go for it. We didn't have to present individual stories, so I doubt this one would be allowed to run. And let me explain why. This was Ohio State, maybe around 2000, 2001, 2002 maybe, and there had been some well-publicized cases of date rape. It had come way up high on the radar, and people were talking about date rape, almost to the point where student bodies, students were becoming suspicious of each other because of the fear of date rape. Well, to be topical and to be kind of in the moment with our participants, I'd written a date rape scenario, and Derek and I conducted this research, Derek Rucker, of this date rape scenario. And what we did was we designed a crime story that centered around date rape that clearly indicated that a date rape took place, or we wrote another version of the story which was extremely ambiguous as to whether date rape took place or not. And then we asked for people's desire to convict the defendant, the young man in the case, described in the case, or not. But what we were doing at the same time, we were also studying how people can be put into a pre-existing mindset, and does that change, in fact, the way that they process information. So basically what we did then was, it's a pretty big study. A lot of our designs were pretty big. This actually works out to be 4 independent variables, if you will. So the date rape scenario provided, and this is where it gets really kind of hard for a lot of people to kind of accept, and I'm halfway there with those people. Based on what was said in the story, was it possible to generate excuses or not? Right? And you know, often we say, well, there's no excuse, and that's true. Regardless, that's not necessarily the way people process information or see their world. Right? So basically what happened is a woman named Sue, which was a popular name in our story, and John were on their 3rd date. They were both Ohio State students. They had gone out for dinner and had some drinks, and in the story they walked back to Sue's apartment. John walked Sue back to her apartment, and then Sue invited John upstairs. Now, in the one case, in the excuses present, she eagerly invited John back up, or she grudgingly invited John back up. So the stories are exactly identical, with just words pulled out and changed to create the difference. Sue offers, once they get upstairs, Sue offers John a drink. In the other condition is Sue offers John a cup of coffee. Sue says that she's going to go get more comfortable, and she goes into her bedroom to change. She either comes out in sweatpants and sweatshirt, or kind of a negligee type item. John lights a candle while Sue's in the bedroom, and Sue comes out and says, "Oh, how romantic." Or in the other condition, she comes out and puts the candle out and says, "I'm saving that for something else." Right? So clearly there's indicators that Sue might be a participant or not, right? And that's where it gets problematic, and I admit that, and I wouldn't do the study again if I was afforded the opportunity, because I just think it's too dicey. In any event, in both scenarios, then they start doing some heavy petting, some kissing, some necking, whatever you want to call it, on the couch, and then John goes beyond where Sue wants him to go, and she tells him to stop. And you know, no means no. She says no, doesn't stop. At that point, in kind of wrestling around, Sue falls off the couch, and we manipulate here the severity of her injury. She either hits her head on the marble coffee table and gets severe brain damage as a result of that, or in fact she just falls on the floor with no injury. You know, so that's kind of the setup. What do we do to manipulate the mindset? Before people read the story, we ask people to either, and the control condition is we ask them nothing, we just let them go on their own. Other people we ask in one condition to function as if they were prosecutors of the case. Read the case as if you're a prosecutor. Other people we ask to operate as a defender. Think you're a defense attorney. And then the fourth condition, we ask people to think they were a judge and attempt to be impartial. So those are the 3 manipulations, right? 3 independent variables manipulated in those ways. The participant gender, of course, is not something we manipulate. This is just something we measure to see if it makes a difference. That is as a moderating variable. So what do we see? When we're looking at people's attention, that is to the high extenuating circumstances, that is that John felt that Sue was probably encouraging him, so that was high extenuating circumstances. Should John pay for his crime, right? What we see then in the bars is those who are asked to operate as judges, which we're calling intuitive scientists, right? And those that were acting as control, we can see that men in the high extenuating circumstance condition thought that he should pay when they were told to be more fair-minded. Now notice, women in this case, and the bar that we thought was essential to understanding what's going on here and to answer the question about bias, is here we have females in high extenuating condition who've been asked to look at it as defenders, that is, they should be on John's side, but notice they couldn't do it. In fact, that's one of the highest bars there. They were the most prosecutorial. This is probably more like a rebound effect that we discussed in the last lecture. They just couldn't get there. And then for the next slide here, this is again high extenuating circumstances, the suitability of prison time. And notice we're using two dependent variables that are different but kind of point the same direction. And we see the same relationship in the bars. So what we see then is that people may acknowledge their bias, may not acknowledge their bias. That's not the issue here, but they demonstrate the bias. That is, within this given scenario, females who are asked to operate as defenders were unable to do so. And you can argue that's with good reason, and I'm fine with that. But this is the research as we saw it. This is the only study we did where we asked people to assume mindsets outright. Other ways we primed people into mindsets without their knowledge so they couldn't correct for it. So let's talk about determining liability in civil cases. Liability should not be influenced by the outcome severity. And notice that this is something we were manipulating in our study. The outcome of the attempted date rape, right, at that point, or the outcome of when the word no by Sue is given and John persists, was either Sue hitting her head or not. Now we can argue that that's a consequence that's one step removed away from the act itself. It's not something John intended for Sue to hurt her head on the table. To what extent should he be held liable for it? And this is very common in civil cases. The jury shouldn't be influenced by outcome severity, how severe the outcome or damage of the injury is. That is John guilty is something that we should process before we have knowledge of Sue's ultimate injury. Was John guilty of date rape, right? What we find is that if Sue is in the injury condition, that is, she was injured, people are more likely to find him guilty of date rape. But notice that's kind of going backwards. You need to find guilt and then assume liability afterwards. Now the law says, and the courts say, that people can separate judgments of liability from judgments of damages. That is, judgment of liability, are you responsible? And then judgment of damages is, how much do you pay? Courts say people can do it. What we found is, no, people can't. Okay. We're out of time for this one, so let me stop this and we'll go to part 2.